Lawyers, what's the dumbest thing you've had to explain to a client? A client in a discrimination case was seeking reinstatement in his school. He was wrongfully expelled. He didn't want money or any type of compensation. He just wanted to be able to attend classes again. When I told him that the case would require a small retainer, around $2,500, plus appearance fees, he said, "No, I'll pay you on contingency." I then told him that he wasn't suing for money, he was suing for reinstatement. There was no monetary award for his actions, so my contingent fee would be 1/3 of zero. He then told me, "No, I mean I'll pay you your fee contingent on you winning." I told him that there were dozens of man-hours involved in bringing his case to court. It isn't fair to pay me based on an outcome that had nothing to do with my hard work. His response, "Well, you better win then." It's at this point that I texted my secretary with an SOS. 2 minutes later, she came in like a winged angel and said, "The consumer, your brother is on the phone from jail." That quickly ended the madness of no-paying tough luck Chuck. Another one, a client came in and said, "Someone has been robbing my checks for 15 years. Huh? He then showed me his paperwork. When I say paperwork, I mean crinkled, folded, balled up garbage that I needed to decipher. When I got to his checks, his pay stubs, I said, "You have checks. You get paid. No one's robbing you." He bluntly said, "Someone named Stu is taking money out of my checks. I want to sue him." Stu? I look deeper and see nothing about what he's talking about. Then on one pay stub, I see deduction SCU. It dawned on me immediately. I said, "That's not Stu. It's an abbreviation for Support Collection Unit. They take money for child support." He looked at me blankly and said, "Child support? I ain't got a child." Again, huh? As I started to ask my next question, he said, "I had a child, but that was a long time ago, like 10 years. I said, "You have a 10-year-old child?" "Yes." "In New York, you have to pay for them until they're out of college, 22 years. He was flabbergasted, more so because he couldn't sue Stu more than anything else. Yikes. Please tell me that in a startling coincidence, his son's name was Stu. That'd make for a better, funnier story for sure. Story 2. So some context, I used to be a lawyer in a small country town. The stories I have. I once had to explain to an elderly gentleman that an argument didn't allow him to jab his neighbor, but he was shouting at me. I wanted him to stop. Now, to be clear, it wasn't self-defense. He referred to it as poking, as in he wouldn't shut up, so I poked him a little bit. That story has an epilogue. After he was sentenced, he was picked up from the courthouse by the victim. They proceeded to go to a pub and get hammered, still best of friends. I had to explain to a client once that an argument over grass, which is illegal here, isn't grounds for him to rough up his neighbor. That same client was quite happy to plead guilty to assault cause harm, but refused to plead guilty to aggravated assault, exactly the same penalty. I had a young Aboriginal client who was on bail for some fairly trivial offenses. He breached his bail about 10 times. I had to explain to him that the court wouldn't believe him when he said he would turn up to court next time because he hadn't turned up to court the last 3 times. As far as I know, he's still in jail. I had to explain to a bloke that he wouldn't get custody of his children after he had been charged with DV offenses against the mother. His justification for wanting full custody? But the mother isn't fit to be a mom. She stayed with me. I have had to explain to a very large number of men why quitting their jobs so they didn't have to pay child support was a very bad idea. To add, in South Australia, your child support is based on your income, but you can make an application to have the other party's income assessed, and in certain circumstances have a deemed income. For example, if you can show that a tradee's income is much higher than their taxable income, such as by showing that their lifestyle doesn't reflect their declared income. You can also have a deemed income assessment where a person is voluntarily unemployed but evidence is necessary. Story 3. Not a lawyer, but I used to work for them. We had one lawyer who was really sweet and kind and soft-spoken, never got mad about anything. So one day I'm walking by her office and I hear talking to who is clearly a lawyer on the other side of one of our cases. "We can't do that because it's subject to privilege," voice rising. "But that's not how this works," voice rising again. "No, I already told you we aren't going to do that," yelling now, "because it's privilege and no lawyer would ever give up that privilege. I would be disbarred for that." Also was sued once for non-payment and libel. We hired a contractor to do some work. He didn't do it. We didn't pay and wrote a bad review. He sued. In his statement of claim, he cited several bad reviews that were written on a review site by one of our employees, John Doe. So things go along and we end up at the pretrial case management hearing. His lawyer lays out his case to us and the administrative judge overseeing it. We listen politely, and when he's done, inform him that John Doe does not actually work for our company, that the reviews he cited in his claim were written by someone we don't know and have absolutely no affiliation with. Our bad review was written by John Smith, which was not included in his claim. His response, "Well, that's for a court to determine." No, you've claimed we wrote reviews that we didn't write. The reviews you cite clearly list the address, and it's not ours. These reviews are not from us and are central to your claim, so you have no claim. Well, that's for a court to decide. And he lets the case lapse, and I assume he didn't want the embarrassment of bringing that up in court. Story 4. That, quite frankly, I don't give a damn. It's the most important thing in your world that you have a court hearing in the morning. For me, it's just another Tuesday. So don't call me at 1 a.m. or email me 17 times overnight. I am not stressed, I'm not awake, and I will not respond. Take an Ambien or something and get some sleep. So I was an idealist. The key word is was. I'm a businessman as well as an advocate now, and I expect to be paid. Bank account running dry due to an unexpected car repair when I invoice? Screw you, pay me or I'll withdraw. Your financial woes are not my emergency. I don't run a charity, and I have bills to pay too. So when you're in a room with me and we're talking, out of the 2 people in the room, only one of us is a lawyer. Your belief you didn't need me got you into this situation in the first place, and now you need to shut up and listen. I have other clients. I will not return every one of your 18 calls today. Leave a voicemail and I'll call you back. Yeah, I'm friendly with the other side's attorney. I have cases against him all the time. We go to the same events, and no, I'm not giving him a break. I'm leveraging this relationship for your benefit. All your friends telling you something they think I should do only carries weight if the word justice precedes their name. They aren't lawyers, and Google and television are not a replacement for training. If you aren't happy with the representation, come get your file. I'm not going to starve. On the same note, this isn't Burger King. You don't get it your way. I'm not a retail clerk. I'm a trained legal professional. You tell me your goals. I determine how to reach them or if they can be reached. I'll consult you, but you're not going to demand I do something I don't feel comfortable doing. And at the end of the day, you're Joe Schmuck to the court. My reputation is my trade, though, and arguing the obscure legal technicality from 1798 you dug up on Google will hurt my credibility with the court and all my other clients as a result. You don't like it? Screw you, come get your file. Oh, you demand I continue to represent you? No, I can fire you as a client just like you can fire me as a lawyer. This is not a criminal matter. The court will let me withdraw. You don't like the invoice for those 18 phone calls? Too bad, screw you, pay me. Go to LegalZoom for that contract and messed it up? Awesome, $2,500 retainer to get started billing hourly. Replenish back to $2,000 on demand. And if it goes to trial, you're looking at a fee anywhere from $10,000 to $50,000. That's too much? Don't use LegalZoom. Pay a lawyer the $1,000 or so I would have charged to negotiate or draft the contract up front. Don't like the cost? Screw you, pay me. Also, stop trying to add me on Facebook. I'm not friending you. I like you as a client. I'm okay with you maybe as a person. I don't want to be your buddy. I'm your lawyer. Story 5. Not in my case, but one that I witnessed when I was still in law school and crossing off my judicial observation requirements, called Rule 403s in my state. It's important for this story to point out that this all occurred in the southeastern United States. So the case involved a burnt-out truck engine. The plaintiff was alleging that the defendant, a drive-up oil change place, had shortchanged her and had only given her 2/3 of the oil she was supposed to have received when she got the oil changed in her truck. She came to this conclusion because her engine fried within weeks of getting her oil change. The defendant's allegation was that they had given the girl the proper amount of oil, and instead, the girl had fried her own engine. It came out through the course of discovery that the girl was known for mud bogging, commonly referred to as goin' muddin'. Now, if you ain't from the South and don't know what that is, it's an organized activity where a group of people get together, usually get buzzed, and then race their trucks in an extremely muddy field. Think drag racing with jacked up pickup trucks on 3+ feet of mud. It's essentially one of the most redneck activities you can engage in. And the defendant's plan to get out of liability was to convince the jury that racing at high speeds through thick mud burned out the engine, not a shortage of oil. To sum things up, the defense was pretty much, quote, the plaintiff is a redneck and screwed up her own car, unquote. So I arrived at the courthouse early to make a good impression, along with 2 or 3 other law students. The plaintiff's attorney sees a random group of people there to observe, and being the nice guy that he was, came over to introduce himself. He explained a little bit about the case, roughly what I typed above, made small talk, and asked us questions about law school, nothing big. After chatting for about 5 to 10 minutes, he excused himself and returned to his place at the counsel table to wait for his client to arrive. Now here's the ridiculous part of this story that is responsive to the question. About 15 minutes after the plaintiff's attorney sat back down at the counsel table, his client walked in and you would not believe how she looked. She was a younger white girl with a shaved head. Even worse than that was what she chose to wear that day. She was dressed in blue jeans, a short-sleeve button-up camouflage shirt, and a trucker hat. Like, seriously, I can't make this stuff up. In a case that essentially hinged on whether or not the plaintiff was a redneck, the plaintiff decided to show up in court in camo and blue jeans. I looked at the plaintiff's attorney when she first walked in. He saw her, looked horrified. He did his best, but surprise, surprise, the jury came back with a defense verdict. I learned a valuable lesson that day, too. It doesn't matter who your client is or how intelligent they may seem. Always go over appropriate attire with your clients before a courtroom appearance. And from what I know, lots of criminal defense attorneys, including public defenders, have a closet of clothing just for their defendants, just in case. Oh, and since you're already halfway through the video with me, please don't forget to hit that like button and subscribe to my channel so you don't miss out on any of my future uploads. Story 6. Not a lawyer, but a property manager, and I've had to appear before the landlord and tenant board numerous times with delinquent tenants. A couple of my favorites. I had a tenant who ended up with bed bugs. Her apartment was treated within a week, which is really good, but she blamed me for the bugs because 6 months ago, someone else in the building had them and took me to the board. I maintained she likely got them from one of the kids she babysat. Among the things she wanted was an abatement for the week she spent living at a friend's place while the apartment was being treated and money for the cost of staying at her friend's place. Her so-called friend charged her to stay for the week. I explained that while some of the costs she was asking for were quite reasonable, like the cost of getting her clothes steam cleaned, I would not be paying for both an abatement and her hotel as it was double dipping. She could have one, but not both. She decided that I was trying to screw her out of money she was rightfully owed and proceeded with a trial where she was promptly told by the board that I did everything right, that my response time in treating her apartment was excellent and well within the board's guidelines of 1 month and therefore had no case against me. So instead of walking out with about $300, she walked out with nothing. Another tenant stopped paying rent, so I applied to evict him. At the board, he gave me a story about his wife being sick and medical expenses, etc., etc. So I worked out a payment plan with him and made sure he was comfortable with all the payment dates. I say, "You're certain you can make these payments amounts and dates because if you are $1 short or a day late, I can and will evict you." The mediator said the same thing. "Are you sure you can make these payments?" "Absolutely," the tenant agrees. Of course, he misses the first payment and we end up back at the board 2 more times and each time the board gives him an extension. Finally, on the 4th hearing, he doesn't show up and I win by default. Later that day, I see him at the building and he asks me if everything is good, that he's not going to be evicted anymore. I had explained to him that no, you will be evicted, you didn't show up to the hearing, I won. There were 3 previous hearings, why all of a sudden would there not be 1? The forms are all the same, you basically wrote the same thing on all of them, why is this time any different? He appealed his eviction, but it was denied without a hearing in its reasoning. The board said he was obviously aware there was going to be another hearing since he asked for a morning slot. Therefore, he can't claim he didn't know there was a hearing. Story 7. Not to a client, but other party. I was acting for a particular manufacturer. They were sued for an injury occurred by someone using a product made by a different manufacturer. I rang their lawyer and I said I was acting for A and I didn't understand why A had been named as a defendant in the suit, but the body of the claim said the plaintiff had been injured by a product made by B. I asked if it was a monster typo or what. The response was that they thought A was the manufacturer of products sold under the name B. Now, that isn't inherently stupid, I guess. So I said that had no basis in fact whatsoever and that A and B were unrelated competitors and asked, as a matter of curiosity, how they had reached the conclusion that A were the manufacturer of B. The response was along the lines of, well, someone in the office, I think maybe Jim, one of our clerks, who thought he'd read somewhere that B was made by A. And that was it. No checking of the product paperwork, no company searches, no brand name register searches, no inquiries with our client or B, not even an F in Google. Just some guy in the office had once heard, and on that basis they issued a very financially sizable product liability suit. Well, that must have been an interesting day for whoever was responsible at Company A. Story 8. I'm not an attorney in any way, so I had a property in Buffalo, New York, bought it at 23, lived for a bit, then moved elsewhere and rented said property. My final tenant was a classic crap storm of stupid. She derped on the rent, I offered a payment arrangement, derped on the arrangement, I sent notice to pay or quit, paid, derped again, sent notice, was told she'd been in an accident and lost her job. A certain acquaintance let me know she did in fact have a job. Lots of top-notch skip tracers in Buffalo, by the way. Literally explained to her on the phone, by letter, and by email that she had enough income to pay the rent and utilities and eat food. She gives in, pays half, and a new payment arrangement, keeps it up for a whole month, yay, then completely crapped out again. At this point, living out of state and looking at property values, I was ready to sell. Struck a deal whereby the tenant could have 2 free months' rent if she signed an early term on lease. Got that, sold the house within 3 weeks. Meanwhile, I served a demand for rent, then filed for an eviction. Court date set, still no payments. The tenant proceeds to inform me in no uncertain terms they're not paying. Night before eviction court texts and lets me know her son is in the hospital and she can't make it. I told her explicitly that if that was true, she would let the court know and I don't give a damn, does not show up to court anyway. Gets settled against for over $3,000. Don't trip over my stupidity, please, plus warrant. Proceeds to send lots of angry texts. The day of eviction, she bails on the property, thank God though, really, and steals all of the appliances. I learned of this at 2 p.m. I texted her at 2:10 p.m. and let her know if she returns the items undamaged within 30 minutes, no harm, no foul. If not, I called the police and filed charges. Ended up filing charges, is now wanted for arrest for grand larceny and does not give a damn. She completely thinks her actions are legit. I waffle between self-shaming for being affable and then being baffled and being angry and being thoroughly entertained. Story 9. Filled in as a receptionist at my dad's firm many moons ago. Dumb son of a long-standing client called in a panic. He had gotten hammered and gotten married in Las Vegas to his long-term girlfriend and baby mama. He said, but it's fine, right? I mean, what happens in Vegas stays in Vegas. So if I never go back, I'm good. I finally figured out that he took it literally and thought that he was only married while in Clark County. I had to explain that no, he was married in all 50 states. He started yelling that he wanted a do-over, so of course that was the catchphrase for the rest of the summer. Some additional info. While I was explaining that he was indeed married to another, secretary passed a note. Is that Rick X? I nodded and she said, give me the phone. She had gone online and found pictures of the joyous event. Rick, log on to MySpace right now and delete all those photos immediately. And for the love of God, make your page private. Brief silence. Why? Because you are on probation. The judge will revoke it and send you to jail. You aren't allowed to leave the state, let alone be drinking and partying. Yes, later on the advice of counsel, he stayed married rather than appear before a judge and admit that he had violated the terms of his probation. Idiot. Well, at least he thought to call a lawyer to check, better than assuming he knew the answer. Story 10. Still a 3L, but I worked in a clinic spring semester as a 2L, second-year law student, and I was handling a family's asylum case. Sparing all the personal details of the case for, well, obvious reasons, but I had logged through my school, the clinic, and personal meetings with the family over 200-plus hours on their case. I had a roughly 85-page document compiling his personal statement, the argument for asylum, country conditions, his family history, every time they entered and left the U.S., and why, etc., etc., and all the copies were ready to be sent off to the immigration office. One problem, though, we still didn't have the recent passport-style photo of each individual family member. Multiple meetings were had trying to get this from them, and every time there was something else wrong. Multiple offers were made to personally drive them to a FedEx office and have the pictures taken, and even then they wouldn't comply. They had complied so well with everything up to this point. I got an email the week of my finals asking if he could have another lawyer handle his case. I'm flabbergasted at this point. My clinic supervisor has multiple meetings with the husband and can't figure out what happened either. I'd been interacting and working with this family for a 5-month period by this time. All that work, and then they refused to cooperate over passport-style photos being included in their packet, which already had multiple photographs of them from their passports and other paperwork. Last I heard, he had emailed the clinic to request that we send him all the prepared paperwork I did. I was traveling by that point, so I wasn't there to hear it, but apparently he got a very long-winded lecture on work product. Well, if you like these stories and learned a good lesson or two just in case for the future, here's more. YouTube thinks you're going to love this. I'll catch you in that video, and thank you for spending time with me on this one.